afternoon.
Good afternoon. May I proceed?
Yes, ma'am. You're Ms. Ross?
Yes, I'm Caitlyn Ross. I'm a member of the Sumner County Bar, and I practice in Gallatin.
All right.
I'm representing Caitlyn Brooke Henson in this matter, and this was on appeal from the Sumner County Criminal Court. Your Honors, I'd like to reserve several minutes for rebuttal.
How many minutes? I'm sorry.
Maybe five. 5 minutes for
Certainly.
rebuttal. Okay.
Were you the lawyer that was in the courtroom when the Miss Henson's presented her pro se petition and you felt like somebody needed to be representing her? Was that you?
No, Your Honor, that was Chad Ross, and we are not related.
Okay.
Or married, which a lot of people ask us. But we practice in the same court, and he heard the proceeding and then picked up her representation pro bono. So this came about initially. Ms. Henson was convicted, and a plea agreement was made. She entered a plea of guilty with diversion eligibility and a sentence of 4 years at 30%, suspended to community corrections. Okay, and then this came about after she had served the 4 years on community corrections. She sent in a letter to the court. She completed her sentence. She sent a letter to the court requesting her expunction. After she had requested the expunction, the district attorney set a hearing for the matter. And so when Ms. Henson came in for the hearing, she understood it to be a hearing to have her expunction signed, not knowing that she would be called on to testify and unrepresented by counsel. If I could just...
Backing up, I'm sorry, I don't mean to get ahead of you, but you said she entered a plea, and I think it was to attempt to possess with intent to sell.
It was attempted possession of heroin with intent to sell.
Okay.
And her sentence was 4 years at 30%.
But this was a sentence under diversion, is that right?
Yes, Your Honor. And so it was a conditional guilty plea.
And it's been a minute since I was a trial judge and did diversion sentences, but or pleas, I didn't think there was a sentence determined at that point. A period of time for probation, and then if the offender doesn't successfully complete, then a sentence is had. Am I wrong about that?
Well, it's basically suspended, and she was suspended to community corrections. And then if she properly completed it, then there was no conviction. So in that regard, there isn't really a sentence. There's sort of a time period and a manner determined. So if she had been agreed to jail time, then she would have served that time. Agreed to suspend to community corrections or to another state probation, then that would be a sentence, but it's not a conviction. There's no final conviction. The matter
but it's really
stays
not
open.
a sentence either, is it? It's a 4-year period of probation or a 4-year period to community corrections. It's really not a 4-year sentence, correct?
Well, it expires, and then at the expiry, it should be no conviction. My understanding is that it's a sentence with a conviction date to be determined upon the successful completion of the sentence.
I was thinking, when I did, we were both all three of us were trial judges, so we always placed people on diversion for a specific period of time without sentencing them. And so it's a placement, and I think that's the way the statute reads or something like that.
That you have a determined amount of time, and then there is no sentence.
And if you fail during that determined amount of time, then there's a sentence imposed. That's when you're back in court, as I recall, to determine how long of a sentence.
But she was placed back on diversion, right?
She was initially granted diversion eligibility. Then, so that was in September 19th of 2019. 6 days later, she had a violation of community corrections and a warrant issued. That would be her first, as in a technical violation. Then they retested her, and there was a second violation of community corrections, and that was on October 10th. So within less than 30 days, she had the 2 violations, and they were for failed drug screens.
And in both of those situations, the state of Tennessee agreed she goes back on diversion, still has the opportunity at expungement.
They did, but they agreed after 7 months of further supervision. So in this case, she was arrested on the probation violation warrant. She went to jail in the Sumner County Jail. She served approximately 120 or so days. Then she was granted on a motion to furlough, a medical furlough. So then she went to the Elam Center, and that was on the 14th of January in 2020. So she serves about 3 months. She goes to the Elam Center. She does a 60-day treatment. She successfully completes it. She comes back to Sumner County Jail, and then she was ROR'd following that. So she was released on her own recognizance, but she still had Mr. Doyle representing, and she was still under the supervision of the trial court. She just wasn't on community corrections supervision. So then they had a hearing on the matter of the probation violation, and that was on May 12th in 2020. So 7 months pass. She does the treatments. She goes in for the probation violation hearing. At that time, she's represented by David Doyle. He's our elected public defender, and he and the state make this agreement, and say she's done all of these things. She had these 2 immediate violations, and the state was represented at that hearing by Jason Elliott, Assistant District Attorney. He did the negotiations on it. They came up with the agreement that she would go back onto community corrections with judicial diversion eligibility. And then he wasn't there during the hearing on the matter. Ronald Blanton, who was then sort of a senior Assistant District Attorney, is now our General Sessions Judge, and he was representing, he did not voice any opposition. So when it came before the court, Mr. Doyle represented it as, we proposed this agreement, and there was no opposition from the state. The trial court then, I'm sorry, did you have a question?
Well, go ahead, I'm listening.
Oh, I just saw
I'm
your
thinking
finger.
as you're trying to
Then the
figure out what my
trial
question
court,
is.
the trial court questioned the defendant, and she answered all of his questions. Mr. Doyle allowed her to be questioned. She answered all of his questions. He said, well, why did you do this? And she said, I had a miscarriage. I've lost a child, had a tough time in my life, and now I've done the recovery. And he says, well, you always have a different choice to make here. You don't have to do drugs when you have hard things in your life, but do you want to have your expunction? Do you want to have your record expunged? And she says, yes, sir. And then the trial court said, okay, that we'll make that order, and I wish you well.
The trial court said, we'll make that part of the order?
The trial court adopted the judicial diversion. Yes.
And this was in 2022?
That was in 2020. So she
2020.
pled the conditional guilty plea in September of 2019. She had the violations. She completed her furlough and the 120 days in jail, released on her own recognizance in 2020, and then in May, she enters the agreement to return to community correction supervision with judicial diversion eligibility. And that is in the order.
Was a hearing that was held in some of the colloquy that you just mentioned, back and forth questioning.
Yes.
That's
Yes, Your
all
Honor.
in the record.
Yes, Your Honor. And I submitted the transcript to that, and it's reflected accurately in the order. In the order, it states that her probation is revoked, that she's placed back onto probation on community corrections for the remainder of her sentence with judicial diversion eligibility and certain jail credits for the time that she served.
All right, now let me ask my
Okay.
question. Has her diversionary period expired?
Yes, Your Honor.
Okay, has she been convicted of any criminal offense?
No, Your Honor.
All right, my third question is, how do you deny expunction in that situation?
What happened is, so she completed the 4 years of supervision. Then she mailed a request to the judge, a handwritten request, because her community corrections officer, the order expired of her community corrections supervision. So in 9/18 of 2023, 4 years after her initial conviction, there was a community corrections recommendation to the trial court that her supervision be terminated. Following that, the next day, which is exactly 4 years since her conditional guilty plea, the order granted the termination of supervision. This is the same trial court. So she's no longer under supervision. 2 months later, approximately a month and a half later, in November, she then writes a pro se request, because that's what her community corrections officer told her is the normal thing to do. to expunge the defendant. The district attorney's office requested a hearing on the matter because of the probation violation. They set it for a hearing. She thought she was going in to have her record expunged, and instead she was taken up to make statements about the probation violation, which happened 4 years prior. So at that time, she'd paid all of her costs. She'd done 4 years of community corrections very successfully, went through the steps to get through it, and she had also successfully completed all of the things prior to the probation violation hearing. So it was at the request of the state that she come forward. Yeah.
Request of the state.
The state requested a hearing on the matter of judicial diversion. So it's called a pro se motion in the documents here, but she didn't understand that she was filing a motion. She wrote a letter. And so that's how we get to the point of her appearing pro se, being questioned by the court. Mr. Ross hears that she's denied the eligibility and says, I'll represent you pro bono. He files a motion to reconsider, which I understand is not an appropriate vehicle for appeal, but the judicial diversion eligibility question is an appeal as of right. So we appreciate the court taking this matter up. Following that, they had a motion on it, a motion hearing, and Mr. Ross presented transcripts from the probation violation hearing where they say, do you want to have the ability to have your record expunged? And argues very thoroughly, which is in the record, all of the motion to reconsider transcript, but it was denied. And one of the reasons that the trial court denied is because they said, well, now that I know what I know about why you had the charge initially, I can't in good conscience give you a judicial diversion.
But he'd already granted judicial diversion.
He did.
Okay, I think what Judge Holloway was asking, on what grounds did the trial court say, I'm not going to expunge your record after all of this time and all of these things you say happened, and I'm sure it's accurate.
Yes.
I don't know how you're keeping up with it so well, but you have, and so has the state in their brief. So all these things happened,
Yes.
And the time has passed, and there's no conviction for
Right.
anything. The whole time, I'm like these two. It would be, when she first entered the plea, there'd be an order, basically like, it's not a sentence, but it's an order pursuant to 4035-313, placing
Yes.
you on judicial diversion.
Yes.
And if she complies with it for the period of time, the charges are dismissed and her record can be expunged. And I don't know.
That was interrupted, Your Honor.
Right, but it was not interrupted by a conviction of any kind.
No,
If
Your
it was going to be interrupted for something she did wrong, which it was, there would have, like Judge Easter said, there would then be a revocation and a sentencing hearing. Basically, you would start from scratch on a sentencing hearing for the
Yes.
crime, and there would be a uniform judgment form in the record saying on such and so date she was convicted of such and so crime, and then we'd have a whole different ballgame as far as trying to
Yes.
get that expunged.
Yes.
But this, what you're saying is the trial court basically said, at this point in time, I'm not going to expunge it because I wouldn't have given you pretrial diversion in the first place. You probably didn't deserve it, or something like that.
Yes, Your Honor.
Okay.
That he basically said that he didn't know the full facts of the case at that time that he made the agreement for judicial diversion.
And this
But-
was the same trial judge
Yes, Your Honor.
throughout the history of this case. It was
Yes,
the
Your
same
Honor.
judge.
The trial judge is D. David Gay, who I very much respect, and I practice in his court 5 days a week.
Certainly,
So.
yeah.
And I clerked for him in law school. So, so
We certainly all know.
We
very
also
well.
we agree with you
Yes.
in that regard. But there was no, he said, if I knew then what I know now, I would not grant you diversion. But there was no further, therefore, the order granting diversion is revoked and I'm going to sentence you on this crime. That never happened, right?
not the word sentence. There is now in the court record a order for conditional judicial diversion. There's no final conviction, and that was prior to me filing appeal. There was no judgment filed.
Okay.
Did the state ever have opposition to your client's expungement?
Only after she had served the 4 years.
After
So,
she had done everything that she had been asked to do?
yes. Yes, Your Honor.
When they asked that her letter be set for a hearing, that's
Yes.
when it turned adversarial.
Yes. And that's one of my points about the requirement of counsel, is that at the point that they brought her back in and she appeared without, she is not convicted, there's no final judgment, they bring her back in, and then the court and the district attorney question her, then we're restarting the adversarial process. And I think that she was entitled to have counsel, especially as an indigent defendant that's been represented twice by appointed lawyers.
Let me ask again, even without counsel, pro se, if your diversion period has expired and you haven't been convicted of any offense, how can you deny expunction as a matter of law?
Well, Your Honor, that's a good question, and I've been hearing this question throughout the courts. I've heard it in general sessions and in criminal courts, and I think that there's confusion about if a probation violation is cause to not grant diversion eligibility.
Well, I think clearly, I think that if a person's already been placed on diversion, there's a violation, I think you can put down an order revoking the diversion.
You certainly can.
But if you don't, the diversion continues the way I understand it, and they specifically said it continued in this case, right?
And as a matter of practice, in this case, yes. And as a matter of practice, other defense counsel like myself are very careful about putting jail credits and judicial diversion. It is not granted after a probation violation to everyone. It's like a gift for the court to put a defendant back on probation. And it's a gift because of the violation that happened or the time period between the violation and the probation violation hearing. In this case, she had 7 months of good behavior, accountability, no future failed drug screens, 4 years of sobriety pass, and then they bring her back in to not grant it. But as a general practice, myself and other defense attorneys are very careful about, if it's not available, we don't put it in the order. If the judge specifically retains eligibility, we specifically put it in the order. And I would note that order was unopposed, that it was signed and put into place without any opposition from the state. She was there at the time. They were there representing the state at the time. I think the question is that they don't know if it automatically. I agree with you, Judge Holloway, that if it's not available, then that determination is made at the probation violation hearing.
I think you specifically have to go in and revoke the diversion.
I do agree with you. And then if there's no agreement between the parties, then you proceed to a hearing that's adversarial. But in this case, there was an agreement, and it wasn't a hearing about what should be done. It was a hearing about whether the court would adopt the agreement of the parties, and the court did adopt the agreement of the parties.
As we sit here today, there's no conviction for this person, correct?
Upon my information and belief, I have no indication that there's a conviction.
Right. So there's a court file in the court up there with lots of pleadings and lots of this, that, and the other, but there's no criminal conviction there, and
No.
the only issue is, should she have the right or be able to get all of that record expunged?
Yes, Your Honor.
And the court said, no, you're not getting it.
Yes, and I mean, the other issue is that she has no final judgment here. So she has open pending charges. She doesn't show a final judgment of
Right.
conviction. The case is just pending, which is detrimental to her life. And that's why I asked in my brief and reply brief that a determination be made about what is appropriate. If it's remanded to the trial court, we've already had reconsideration. And also, if you say, okay, let's remand to the point of the probation violation, she served the 4 years. There's nothing left for her to serve to be taken into consideration there, and that's why I've moved this court to expunge her record and dismiss the charges against her in consideration of the fact that she's done the agreement was standing, that she would retain judicial diversion, and she has done everything she was supposed to do, so the charges should be dismissed.
Couple of points. Do you agree with the state that our job is de novo?
Yes, Your Honor. Not only do I agree with the state on the de novo, but I would like to reserve that argument for briefs on account of the fact that we do agree. We just agree for different reasons. I think the electroplating factors should come into play, and that if she's denied, that those factors should be gone through before the denial. They think that it's denial de novo for another reason, and so I'll leave that to the court.
And then secondly, do you agree that this court, or disagree, that we can just end this? We can determine, yes, her record is expunged, or no, her record is not expunged.
Well, Judge Easter, I actually don't know an answer to that. I mean, I hope that you can. I certainly hope so. I don't know, to tell you the truth, but I can't think of a good remedy aside from dismissal.
Well, I know in our other cases that we look at, there are times, if the record is sufficient, that we can fashion a sentence without having to send it back to the court to do it. And maybe this is one of those situations where if there's enough in the record, we can make that determination without sending it back.
Well, that's certainly what we moved for, and also, but what you can do as the reviewing court, I don't know entirely. I hope that you can. Other attorneys have told me that you can. I don't have there's not a lot of case law on this situation. I think it's a little bit unique, and I hope that you can. I would also like to say that it's very important to myself and the other members of the defense bar, on account of the fact that we don't know the value of our agreements right now, and that the cost to the state, if their agreement is violated, the defendant receives a new sentence, goes to jail, a sentence becomes imposed, but we don't know what the value is of our agreements in terms of if our defendants' rights if our agreements don't have the value of the state keeping their side of it, then how do we ever put them back into the position that they were? And here, that's why I think that entering a dismissal and signing the order, which is in the record as well, is appropriate. Instead of remand. I'd also like to say that if the court wishes, I would be happy to run another TBI diversion check, just to ensure that there have been no other convictions, although I find none in our court system, and Ms. Henson still does reside in Sumner County.
Well, we certainly, I think, could remand with instructions to the trial court to dismiss these charges and expunge the record. I mean, that's a little bit different than us saying the charges are dismissed.
Whatever the court feels is appropriate.
But my recollection on judicial diversion, just like these two, I think, was basically when the defendant is placed on judicial diversion, you tell them, if you do what you're supposed to do, there's two things that are going to happen that are very excellent for your life, and that is the charges will be dismissed and the record can be expunged, period.
Yes, Your Honor.
And so the time passes, they do what they're supposed to do, and those things happen. I don't think I've ever had one, I haven't seen one up here where if those things happen, then the trial judge has the opportunity to come back and say, well, I don't think so in this case, because now I know more about it than I did before, and I don't think we're going to do this. I mean, I'm just not familiar with that being part of the procedure. The general may get up here in a minute and tell me that is part of the procedure, and that's exactly what should have happened. I'll look forward to his comments, but we have used up most of your time at this point.
Yes, Your Honor, and yeah. I'm happy to waive my rebuttal period. Thank you so much for the great questions. I'd also like to note this was my first time in front of any court of appeal, and
Can't tell it.
I certainly appreciate your patience with me, and we look forward to hearing your answer in this matter.
What they say is, if, as an appellate lawyer, if the court asks a lot of questions, that's supposed to be a good thing.
Is
we're
it?
Interested.
Okay.
So, but you
Okay.
probably won't get this many questions every time you're up here.
Okay. Well, I look forward to practicing in front of all of you again. Thank you very much for your attention.
Thank you.
Certainly. All right, General, clear this up for us, please.
You know, when you're in a hole, you quit digging, you know, remember that rule.
Oh, absolutely.
You're gonna get out of it.
Good afternoon, Your Honors. May it please the court. I'm Ben Ball on behalf of the state. I'll be upfront with you. This is not the case that I would have selected to be my first argument of 2025, but I feel much better about it being the first argument of 2025 than if you put it in December of 2024, because I would feel decidedly like the Grinch who stole Christmas. Because I don't think that Ms. Ross's view of this case and my view of this case differ all that much, and I'll be frank with this court. There have been first-degree murder cases I've agonized over less than this case, because the central point of disagreement here is important. And every time I look at this order that's put down while the defendant is on judicial diversion in response to this violation, I read it very differently. I don't doubt that there are the peripheral things that Ms. Ross has talked about what the parties may have intended.
Is this the same order that you said is not a model of clarity?
It's not a model of clarity.
I believe that's what you said in your brief.
And I stand by that. Because I want to be clear here, there is a problem in this case, and I don't think the state is trying to get around that. That's what I find so frustrating, is because of the procedure of this case, getting back to rectify that problem, in my view of this case, is difficult. And the reason for that is because what the trial court said at the revocation hearing was not, I'm placing you back on judicial diversion. That would make things much easier. Because like you said, Judge Holloway, I agree 100%. If they are on judicial diversion and they complete judicial diversion, then anything dealing with the expunction is essentially ministerial. They get diversion. The problem is this order where the trial court says, one, that the trial court is revoking, imposing a sentence of time served, and then returning not judicial diversion, but to community corrections. Now, granted, it appears that community corrections was the one actually administering diversion here. But what we have here is the word revocation and the imposition of a sentence. Now, what makes this even more baffling is there's never an order put down. I mean, a judgment put down. So what we have is sort of this zombie diversion, whereas I read what Judge Gay is saying is he's saying, I'm going to revoke you. I'm going to put you on community corrections, but I'm also going to dangle this carrot of eventual expunction for you. You remain eligible, and he cites the statute. It never says you're on diversion, so you remain eligible for this. I read that as talking about expunction. That is not something he can do as I read any of these statutes. There is no because it's not fair to anybody involved. On one hand, it's not fair to the state who, if they're going to get full revocation, they want a full revocation, not hanging out this benefit, because the defendant, once it's expunged, may as well have finished diversion. But it's not fair to the defendant either, because they don't have that same level of certainty about what's going on.
But apparently, in the record, when that happened, no one from the state said, "Judge, you can't do that," or "Hey, that's a great idea. We join that."
That's 100% right, and that's what makes this so tough, because I want to acknowledge, I can't see any, looking at this procedurally, well, someone should have appealed. How does one appeal this? If you're the defendant and you think that you're still on diversion, which, in fairness, the word revocation here is used. I think that's a signal, but I fully understand how someone might say, well, I can't appeal if I'm on diversion, and why would I? Even if they don't think they're on diversion, they're still dangling this carrot of, you can get your record expunged. And if you do that, you may as well have stayed on diversion. So what we don't have is an appeal from this order, which frankly doesn't make a lot of sense. What we then have is an expunction hearing. And an expunction hearing is not a collateral challenge of a revocation hearing. And that's the problem I have with this. I'm extremely sympathetic to what's happened to the defendant here. And if this court sees more ambiguity to this order than I do, perhaps some sort of remand is in order for more clarity. What was the intent here? But as I read that order, it's a revocation, and it does something that it just simply cannot do. But unfortunately, we're not here on whether that order was correct. We're here on whether the expunction order was correct. And if they were revoked, they're not entitled to expunction. So that is the state's position here. I think all the talk about this as sort of some sort of plea agreement, whatever, that goes to like a collateral type proceedings. What we haven't had here is a hearing where everyone gets up at the hearing, they put on evidence, and they say, this was my understanding of what we were doing. And as this court knows also, whether you concede to a violation of probation is not the same as a plea agreement. I'm not saying that there might not be contract principles involved here. I just don't think this court can get to them through an expunction hearing that didn't put on that kind of proof. So this is certainly an unfortunate order. This order, as far as the revocation, like as you noted, I said it's not a model of clarity. It's not. But unfortunately, I think it's that order that needed to be appealed here.
So does the state think this case is still pending against the defendant?
That is an excellent question, and I think that's the most troubling thing about this is that like I think I referred to it as sort of a type of like zombie diversion, because while there's no criminal conviction ever entered, it just sort of hovers out there because they don't get the benefit of the expunction. So it's this type of order from the trial court is harmful either way to one party or the other. And it is a shame that it wasn't dealt with at the time. I wish I had a procedural route to steer you back to a way to
Let me
get
ask you
to it.
Judge Easter's question. If we look at this record and just take the whole record as a whole, everything that's in front of us, and we decided it is a legitimate appeal for us to do something with, do we have the legal authority to simply say, enter an opinion and a judgment from this court that says these charges are dismissed and the record shall be expunged?
So if this court can find a way to say the defendant was not revoked from diversion, and I don't know, given this order, this court can.
Well,
if this court can, if the defendant was on diversion, then yes, I think this court can absolutely say that her record should be expunged. That should have been the result of and she can appeal an expunction denials, which is what I read this appeal as being. And yes, if that's the case, but unfortunately I don't see how the court gets there. Like I said, I've agonized over this, and because there is a problem.
And you don't see how we can get there because the word revocation is used in this less than model of clarity order.
So I don't think the word revocation was the problem, was the lack of clarity there. I mean, I think it's a very clear word in what he intends to do, and the judge even says he imposes a sentence of time served. So there's a sentence being imposed. It's the problem is here then he also turns around and says, but I'm gonna hold out eligibility, not diversion, eligibility under the statute, essentially for expunction. It's not just not a model of clarity, it's an order that is at odds with itself.
Without diversion, would this be an expungable offense? If she pled guilty to it, she couldn't have gotten it expunged. If she was convicted of it, she couldn't have gotten it expunged.
She couldn't have. So she has to be on diversion to get it expunged. And that's the rub here.
How can we take this mess up? I mean, you got the DA and you got the judge, and I guess you got a defense lawyer, not this defense lawyer, but a defense lawyer. And now hold this against the defendant who has gone through a period of time that she thought was a diversionary period of time, maybe it's a probationary period, but she's gone through that. She's never been convicted of anything, and say, sorry, you still can't get this expunged under the expungement statute. I just don't see how you do it.
I understand your feeling on that. My response is I don't see how you get back to it if she's not revoked. Now, I'm not saying this is not unfair. It's unfair to everybody. This order, and ideally it would have been appealed, but I also understand the unique posture of this, that no one would be incentivized to have appealed it or even maybe realized they could have. And I think I suggested in the final issue, and I mentioned it here today, that if this court felt like at the revocation or non-revocation order, as the case may be, were truly ambiguous, there may be some way to remand for some clarity, clarity in the trial court's expungement order or denial of expungement order as well. But without that, I don't see how this court gets past the revocation.
You don't have any information or facts that from the record that would tell you, though, that Ms. Henson did everything that was asked of her. Is that correct? She has done everything that was asked of her.
I mean, after the revocation hearing, I presume that to be the case. I have nothing to tell me otherwise.
Paid all of her fines and costs, things that we rarely used to see as trial judges. She's done it all.
Look, if she turns out to have been if she was on diversion, yes, she did it, and she's entitled to expulsion. That's what makes this case so frustrating. Is that it's like we're trying to collaterally attack something that we can't quite get to. We can't get our hands around it because it's not the subject of this appeal ultimately.
The good old days to be a chancellor again.
Yeah.
So
Take care about this in a minute.
But before I wind up here, let me offer this court one more solution here. It may not be ideal, but given the complexity of the procedural aspect of this, and this appeal was definitely untimely, this court could always dismiss it.
How can you
It's
say,
untimely.
argue that when we've been talking about the interest of justice?
I understand.
Your whole argument has been interest of justice.
I think if you look at the interest of justice, you also look at, can this court actually get to the question posed? And if the court can't, I'm not sure that it does a lot of good to put down an opinion saying, essentially, we've been presented an unsolvable puzzle. No one been, this is how this ends. I'm not sure whatever opinion came out would have a lot of precedential value, except for maybe warning against this style of order.
And that would be a good thing, don't you
That
think?
would be a good thing. If I never see an order that looks like this again, I would be very happy.
I, for one, appreciate your authentic argument.
Well, thank you, Your Honor. It's rather be making a different one, but I have racked my brain on this one, and I have no one to blame but myself because I don't know if you know our office's procedures, but I assigned the cases out to my team, and I thought, hey, this looks interesting.
There's some law out there, and I don't want to overstate it, but a plea agreement is sort of a quasi-contract, and if the defendant fulfills the terms of the contract, they're entitled to the agreement. And this is almost an agreement by the state, and of course maybe it was interrupted, that if you do this, you'll get diversion. Maybe they should have been more clear in the probation order. And then she does what unilaterally she thinks she's required to do to get expulsion, and then she said, no, I can't get it. I don't know if you can get to a contract argument on this or not, but that's, it just seems unfair to the defendant to not grant expulsion. Again, the lucky thing is it's not the biggest case in the world. That's for her maybe. I'm just saying it's not a murder case where we've got this kind of mess.
So a couple points on that. I agree that there is a world in which we're looking at the contract sort of law here surrounding this. This is not that case, unfortunately, because I think because of the procedural posture we're in. Like I mentioned before, there has not been a developed sort of collateral attack sort of based on the voluntariness of the parties, what the agreement was there a meeting in the minds, and that's not sussed out at this hearing. I think when you actually get in the record, you're going to see it's very sparse, and we don't have all that periphery. I don't doubt for a second what my friend on the other side says about what took place around this proceeding, but what we have is really just the bare facts of the proceeding. We don't really know what the discussions were behind the scene, and we haven't had a well-developed hearing like we would in a normal situation where someone tries to withdraw a plea, where they are discussing what their understanding of that plea was. I do think we can have contractual principles apply had this been a appeal from the revocation hearing and then it had been developed, but that's just not, unfortunately, what we have here. And I'm not sure from the record that we can get anything. That's my other point. Like from the record itself on the meeting, when there was a meeting of minds, or even there was a deal here. But I don't disagree that the defendant, unless counsel told her otherwise, likely viewed this as staying on some form of diversion.
All right, General. Excellent argument. Thank you. Well briefed.
Yeah.
Thank you, Your
I'm
Honors.
going to end your time for you before they ask anything else.
Let me just finish by asking this court to affirm the judgment.
Just kidding.
Thank you, Jim.
Thank you, General. Did you say you're going to waive your rebuttal, or you want to add some more to this? I can't remember what you said when you sat down. I thought you said you waived your rebuttal time.
Well, Your Honor, I did waive my rebuttal time because I felt I went so over.
Well,
in
that
my
was a
initial-
lot of us talking too, so if you want a couple minutes, have at it.
Okay, thank you, Your Honor. Just
Certainly.
briefly then, regarding this agreement that was made, and if we're talking about the agreement that was made, I understand the expunction hearing that we had is where the issue lies, because that's where the state sort of changed their mind about this. However, Ms. Henson was unrepresented at that hearing. She came in thinking this was my expunction to sign it, and she was not on supervision anymore because it was completed. It was completed, and an expiration order was signed. So the agreement that was made that's relevant here is the agreement that was made at the probation violation hearing, because the state and her counsel, David Doyle, made an agreement that she would return to community corrections with diversion eligibility, and that was ratified by the trial court. And so even though the expunction hearing is the point at which we're appealing, the agreement that was made was 4 years prior to that. And that's the agreement that I think is important, because that's the one that the state backed out of.
Again, I go back, if we dismiss this case, there's no conviction, how can there not be an expunction based on the expunction statute? There's no convictions. You ought to have a right to have it expunged. And I don't see how you don't dismiss it, whether it's a probation revocation or you got a probation revocation where there's no conviction.
Yes, Your Honor.
It's probation monitoring the diversion period, is all they're doing.
Yes, Your Honor. Yes, and then they ended their supervision at the 4-year mark, and the trial judge signed the expiration order. So that's why I think that where this turned around is them trying to go back to 4 years earlier and say that should have been a hearing, but there was an agreement in place, and the trial judge also questioned the defendant during that and found his questions well answered. And that's why the language about the revocation and should it be not revocation, should have been, I have no idea what the right thing to do is. To tell you the truth, I'm being very careful in my orders after this because I don't want to do the wrong thing either. But I think that the record reflects that there was an agreement of the parties. It was ratified by the trial court.
If you have a client who's on judicial diversion and there's a bump in the road like here, but the judge agrees to continue the judicial diversion, to give her another chance, do not, under any circumstances, use the word revoke or revocation in the order that you prepare.
And I never will again. Yes.
That's my unsolicited legal advice when you were saying you don't know what to put in the orders. Because to me, if you revoke it, then there has to be a conviction, and there's no conviction here. So
Right.
the word revoke may have been used, but like I said, it was more of a bump in the road, but let's stay on track here, give her another chance on the diversion, which apparently she did well
She
from
did
that
very
point on. It may have been-
She is very grateful for all of the opportunity, by the way. She's not here, but, she turned her life around. She has a family now. She has had no reported drug use or violations, that way no further charges. So she remains very grateful. It was actually the defense bar that was like, something's wrong here. So we're all trying to figure it out, and we appreciate your direction. We'll certainly listen to anything the court has to say and implement it to change our practice procedures as well. Thank you so much.
All right, thank you. And let's take a 5-minute recess, and then we'll get the other cases knocked out here.
All rise.